Welcome to our channel. Today I will be discussing with you why your lawyer is not communicating with you or apparently not responsive to your requests. First off, a little bit about our law firm and myself. We are a New York and California-based corporate intellectual property law firm. I am attorney Louis Liu. I'm a corporate lawyer. So there are 5 categories of potential reasons that your lawyers are not communicating with you. First, are they your lawyer yet? Have you signed an engagement letter with the lawyer? As I explained in my other videos, in New York, the conventional practice is that for any client matter with expected legal fee of over $3,000, your lawyer should have a written engagement letter with you. And before then, your lawyer needs to check whether there's any conflict for them to, and their law firm to represent you on a specific matter. For example, in a divorce or any kind of adversary proceeding, a law firm and a lawyer should not and could not represent both sides of the conflict. And most lawyers, once again, after that, need to sign the engagement letter with you before they actually start to review documents and do the substantive legal work and communicate with you, right? And some law firms will require upfront payment before they actually do much work. And second, are they your lawyer? You may have paid a legal fee for a lawyer, but it's not your lawyer. For example, a parent may pay the legal fee for a child, an adult child or a teenager child who is implicated in a criminal case, but the attorney is duty bound only to talk to the child because the attorney-client privilege belongs to the child, although the parent, the legal custodian, may have signed an engagement letter and paid the legal fee. Another example, right? Several business partners engage a law firm to help them form their new company so they could start a new venture. But the lawyer insists that there shall be no ex parte communication. What does that mean? Ex parte means communication between one side and or the judge, which is what originally means, but here a lawyer. In the United States, if 2 lawyers are litigating one case in front of a judge and one lawyer arrives to the court before the other lawyer, that lawyer, the first lawyer, is not supposed to talk to the judge about the case at all because the fear is that he may, in the absence of his opposing counsel, exert some kind of wrong influence upon the judge. And the same thing is true here. The corporate lawyer is being very ethical. He does not want to get too much input from one of the funders and be unduly influenced by one of the funders because his duty is to represent the entire company, and which is kind of abstract. But in example 3, it becomes more clear. For example, a lawyer, you may work for a hedge fund. The hedge fund is investigated for insider trading, a crime, right? And you may be one of the traders that is subject of that investigation. And actually, the lawyer for your company is not your personal lawyer. You will be naive if you actually talk to him and mistaken him as your lawyer. And that's why he or she may not be talking to you in his or her capacity as lawyer, as your lawyer. Third, is your request the reason for your lawyer not to respond to you? Is whatever you're writing to him or calling him to do within the scope of his or her engagement? For example, you hire a lawyer to help you set up business partnership, a new company, right? But you expect him to draft your business plan, which is essentially your own work, right? But probably he or she would not, really mind if you pay him or her by hour. But if you have a fixed fee arrangement and you try to give the attorney work that's not, within the scope of engagement, then, some of them may explain to you, others may just ignore you. And for another example, you hire a lawyer for the sale of your business or for acquisition of a business, right? You cannot expect him to lead the valuation process. It's a business decision. You either do it by yourself or you hire investment bank or business appraisal firms to do that for you. He or she could have some sort of input, but you cannot expect them to lead the process. Or worse yet, are you requesting your lawyer to do something that's not appropriate or not lawful or ethical? Most lawyers will ignore you. They will not even bother to reply, to decline. And fourth, are you using the right mode of communication with your lawyer, which could be important. A lot of lawyers hesitate to put their legal analysis in writing. So they may prefer to sit down with you and go over things in face-to-face. And if there are other kind of confidential or sensitive information involved, a lot of lawyers are very, very careful. They may not even want to leave a lot of email trace there, and particularly if it involves the judgment call they have to make for you, because they don't want to be accused of a malpractice or worse. And also, a lot of lawyers are trying to preserve attorney-client privilege. So by not responding to your email or phone calls, they're doing you a favor. For example, if you write from your work email address, most lawyers will not reply there if they are careful, because there are cases out there that essentially hold that anything your lawyer sent to your work email address, the attorney-client privilege between you and your lawyer is lost. And your lawyer usually will not reply to an email message in which you have copied other people who are not, the client, because you individually may be the client or your company may be the client, given that you have the authority to deal with the lawyer on behalf of the company for that specific engagement, right? But if it's non-party, then your lawyer would not reply and copy that party, because then attorney-client privilege will be lost. And then fifth is the person still your lawyer, right? Most law firm engagement letter provides for termination if legal fees past due. And some law firms will send you a formal disengagement letter upon completion of a matter. Other firms may not do that. But if after a long time after the case, a matter has been closed, you're contacting the lawyer, or if you have not paid a legal fee, then maybe as a client has been terminated, right? By the way, a client generally can terminate a lawyer without cause, but the client should still be liable for the fee accrued up to the point of termination. So this is today's topic. Thank you for your attention. If you are interested, you may subscribe to our channel. Thank you.